Hello, I'm Jess. I'm from Naral, Pro-Choice, Minnesota. I am the SCOTUS project director, and today I'm going to be giving you an overview of what a TRAP bill is and Whole Woman's Health v. Hellerstedt. So what is a TRAP bill? TRAP stands for Targeted Regulation of Abortion Providers and places unnecessary and burdensome restrictions on abortion providers. They are often introduced under the guise of women's health, but have nothing to do with it. Their intent is to close abortion clinics and cut off women's access to abortion care. An example of a TRAP bill that we have seen here in Minnesota would have required our 5 abortion clinics to meet ambulatory surgical center standards. So our clinics would have had to have proper hall width, room sizes would have had to be to a specific requirement, and they would have had to have a certain number of bathrooms. These are incredibly costly regulations and have nothing to do with the procedures, the safe procedures that are being performed in our abortion clinics. It's important to note that these regulations have nothing to do with women's health. Abortion is an incredibly safe procedure, safer than getting your wisdom teeth removed or getting a shot of penicillin. So I'm sure you're wondering what this TRAP law has to do with us. The Supreme Court is hearing a case out of Texas. It's Whole Woman's Health v. Hellerstedt. In 2013, Texas passed a law, HB 2, that placed onerous restrictions on the abortion clinics there. A result of this bill was Whole Woman's Health sued the state of Texas, and the Supreme Court is now hearing it. There are 2 provisions of the law that they are specifically looking at. An ambulatory surgical center requirement requires clinics to needlessly convert into mini hospitals at great expense. These requirements are not medically justified, do not improve patient care, and often require facilities to undergo new construction or costly renovations. For this reason, very few abortion providers can afford to comply with this unnecessary requirement. The other provision that they're looking at in the law is the admitting privileges provision. This requires doctors who perform abortion care to have admitting privileges at a nearby hospital. But nothing ensures that hospitals will consider the request, let alone grant such privileges. Therefore, even doctors who make every effort to comply with a mandate but cannot gain admitting privileges will be driven out of practice. I think it's really important to note here that abortion is incredibly safe and there are complications less than 1% of the time, and regardless if there is a complication, women can always go to the nearest hospital. You might be asking yourself whether these provisions are truly about promoting women's health. The answer is a resounding no. The American Medical Association, the American College of Obstetricians and Gynecologists, and other leading healthcare experts are united in opposing these burdensome regulations, stating they serve no purpose and are not based in scientific facts or best available medical knowledge. There are 3 opinions that can come down from the court, and we'll be going over what those can be in further videos. Thank you so much for watching, and I'll see you next week. I'm Jess from Naral, Pro-Choice, Minnesota. And of course, don't forget to check out our website, Facebook, Instagram, and Twitter for our latest updates.